In a major relief to the HDFC Bank, the Bombay High Court has quashed the reassessment notice as the jurisdictional condition for invoking the power under Section 147 of the Income Tax Act was not satisfied. Stop. The division bench of Justice N. J. Jamadar and Justice K. R. Shriram has observed that once it is held that the jurisdictional condition for invoking the power under Section 147 is not satisfied for a particular assessment year, the notice for reopening cannot be sustained. Stop. Then it does not matter that the assessee did not assailed the notice for reopening in respect of preceding or succeeding years. Stop. The petitioner assessee is engaged in the business of banking. Stop. The petitioner has numerous branches across India. Stop. The petitioner being a scheduled bank and having branches in rural areas is entitled to deduction under section 36 bracket 1 of the Act 1961 for bad and doubtful debts equivalent to 7.5% of the total income and 10% of the aggregate average advances made by the rural branches of the petitioner. Stop. The jurisdictional assessing officer issued a notice under section 148 of the Act 1961 proposing to reopen the assessment. Stop. The assessing officer was of the view that there was failure to take into account the enhanced deduction under section 36 bracket 1 while allowing the deduction towards bad debts in assessment year 2006-7, and thus he had reason to believe that income had escaped assessment for assessment year 2006-7. Stop. Eventually an assessment order was passed under section 143 bracket 3 read with section 147 of the Act 1961 revising the total income. Stop. The petitioner averred since the notice came to be issued beyond 4 years of the end of the assessment year 2006-7 and assessment under section 143 bracket 3 of the Act 1961 had been effected not once but twice, the resort to the provisions contained in section 147 of the Act was impermissible unless there was failure on the part of the material facts for the purpose of the assessment. Stop. The aspect of alleged misclassification of non-rural branches as rural branches was specifically raised and enquired into by the AO. Stop. Thus, there was no reason for forming the belief that the income escaped assessment on account of failure to disclose fully and truly all material facts necessary for assessment even remotely. Stop.